Good afternoon, ladies and gentlemen. So we have a smaller group up here today. Just so you know, the Senate had some other plans and a conflict, so they're not mad, and we're all good. So we will continue on with the work of our working group today, and before we begin with the scheduled presentation, do any of the other House members here have any personal orders or announcements? Yes, Representative Hill.
Thank you, Madam Chair. I just wanted to take an opportunity and point of personal privilege to congratulate you on putting together a fantastic program. I know the Senate's not here right now, so we get to sing your praises specifically. And also, it's a tremendous honor to be able to be back on a committee with you and sitting so close. So great job with this working group, which is a difficult subject, as we all know when we're talking about the subject matter that we are, but you have done a fantastic job, and looking forward to what's next.
Thank you. You're too kind. It takes a lot of people, from our researchers, people in the background, and the members giving of their time. So I thank each and every one of you, and our Senate members who are not here. We will be sure and thank them too. We thank you for out here in the audience who took the time to. It's not an easy trek to get up here, but we appreciate your effort to come and join us. And those watching, we appreciate your interest in this. We are all trying to swim through the deep waters of what this means. So thank you for your patience. And we thank all of our supporting staff that has helped us with getting answers and people here. So this afternoon, we have two individuals that will be making their remarks. And so if you all will come forward, and we will, if you will introduce yourselves and tell us who you are with before we get started. And there you see the button on it, yeah.
Thank you, Madam Chair. I'm Sal Nuzzo, Senior Vice President with the James Madison Institute, which is a public policy think tank based in Tallahassee, Florida.
I'm Steve Johnson with the Center for Practical Federalism, where we love federalism, and happy to talk about the importance of federalism, the idea that our nation has some powers, but most powers lie with the states, local governments, and the people.
Thank you for those introductions. So members, we will take your questions once they have made their presentations, and as usual, at least I only have to look one direction today to see who would like to speak, but don't be shy. All right, please start. I don't know who wants to go first, but we thank you all for coming up.
I'll begin. And Chairwoman Moody, members of the committee, I'd like to thank you first off for the opportunity to be with you today. As I'd mentioned, my name is Sal Nuzzo, and I'm with the James Madison Institute in Tallahassee, Florida. Today I'm speaking on behalf of our National Blueprint Florida initiative, which is aimed to come alongside policymakers in all 50 states interested in unpacking principled policies that reduce federal overreach and increase state and individual autonomy. So this issue is something that is near and dear to our mission. I understand that we're here today to assess the strings attached to receiving federal education dollars as you kind of investigate whether or not that's a viable policy path. Before I dive in, I'd like to suggest that we aren't just here to consider what conditions may be attached at this moment or even during the 2023-24 school year. We have to consider that strings, conditions attached to federal dollars are not static. They can and do change at the discretion of the federal government and the bureaucrats in charge there, regardless of whether or not they serve our students' best interests. So I'd like you to consider Kentucky and Illinois and how those states were treated by the Federal Department of Education since 2017 when they began implementing new ESSA, Every Student Succeeds Act requirements, and transitioned off of the No Child Left Behind Act. So Kentucky and Illinois were each warned by the US DOE they might lose a portion of their federal funding because of what the US DOE saw as problems with their testing quality and equal access. So simply put, the states were expanding and enriching their testing requirements and the options available, but their attempts to do so and measure student performance with them did not align with the federal government's prescription. So in 2016, Kentucky, in particular, was reprimanded by the feds who had threatened the state's federal education funding for disadvantaged and special education students because its science test, aligned to its revamped science standards, didn't include metrics for basic, proficient, and advanced, as required under both the NCLB and ESSA. Kentucky was in the process of switching to another deeper science test, so differentiating performance levels at that point didn't seem to make much sense according to their department at the time. And going back to the state's old test wasn't a great option either, since it didn't align with the different standards that they had adopted. Now, in Illinois, they had pursued a new assessment system, triggering US DOE to place the state on a, quote, high-risk status for jeopardizing federal funding. The state had let its districts choose from a menu of high school tests. Supposedly, ESSA allows districts to offer a nationally recognized high school test to their students instead of the state exam. The Land of Lincoln had apparently noted to the department, but the administration, the federal administration, explained that the new requirement still does come with strings attached, without even outlining why Illinois would be in violation of any of those conditions. And the US DOE sent the state a threatening letter accompanying that feedback. ESSA has been touted by agencies and academic elites as the flexible alternative to the No Child Left Behind Act, bringing with it the promise of increased innovation, opportunities for states to design different pathways for student achievement. Now, we would contend that promise was disingenuous at best, and we've seen little for the investment in our states and having implemented the new program. So questions have been raised about what these quote-unquote strings attached have meant on a practical level. So I'd like to examine a couple. For any district that receives over $30,000 from Title IV-A, that district must conduct a comprehensive needs assessment on the 3 areas provided for in that section. The funds assigned as follows: at least 20% for activities to support well-rounded educational opportunities, at least 20% for activities to support safe and healthy students, and a portion of funds for activities to support effective use of technology. Well, what does, quote-unquote, a well-rounded education mean? Well, it means whatever the federal bureaucracy determines it means at any given time. Some of the qualifying activities they broadly publish include increased access to enrichment programs for, quote, underrepresented groups. Now, how is underrepresented defined? Also left to federal discretion. Another qualifier is strengthened instruction in certain subject areas such as civics, economics, and environmental education. Now, how are those enriched instructions determined and approved? Also left to federal discretion. So what does safe and healthy students mean, according to ESSA? That also means whatever the federal bureaucracy determines it to mean at any given time. Now, I'd like to highlight one specific criteria that can be interpreted by federal bureaucrats, and that is providing school-based mental health services and counseling. Unfortunately, we can cite a few cases from my home state of Florida that tragically demonstrate the sorts of mental health and counseling services that schools are providing with these federal provisions. In one case, the parents of a 12-year-old girl filed suit in federal court, challenging federally sanctioned mental health and gender identity counseling that their daughter had received for months without the parents' knowledge. They were only informed after their child had attempted suicide in the school bathroom on 2 separate occasions. The lawsuit cites violations of the parents' custodial rights under the Florida Constitution, as well as the 14th Amendment to the U.S. Constitution. I wish this were an isolated case, but it is not. The Child and Parental Rights Campaign filed suit late last year in my home county of Leon County, Florida, in Tallahassee, when local officials had a similar incident involving a 13-year-old girl. Related suits have also been filed in Wisconsin as well as California. Now, the most important part of this legally is that in all cases, the school districts claim they implemented federal guidance on such issues. So let me pause for a moment and note, and I cannot stress this enough. While federal agencies often represent guidance as settled law, federal courts and the Office of Management and Budget have made it clear it is not. The fact is that if agencies want to attach new regulatory requirements to the grants that they give to states, they're required by federal law to follow the Administrative Procedures Act, which affords room for public comment as well as legal challenge. Federal guidance is issued directly by agencies to the state agency officials charged with administering those grants that the state has received. All too often and all too common, both the federal and state agencies implement that guidance and then represent it to state administrations as well as legislatures as federal law and raise the specter of prosecution and lost federal funds if the state does not comply. So whenever you hear anyone cite federal guidance as a reason to alter or undermine the will of Tennesseans as expressed by you, their duly elected representatives, I would encourage you to consult with knowledgeable attorneys. And now to continue. Another vague and discretionary qualifier for fostering safe and healthy students as prescribed by ESSA is the criteria of, quote, promoting supportive school climates to reduce the use of exclusionary discipline and promoting supportive school discipline, end quote. Now, what could that possibly mean? Well, let's consider the controversial interpretations of appropriate gender identification and use of pronouns in school. And I'll use my home state again. In Florida, a law passed last year requires K-12 policy to reflect that it is, quote, false to ascribe to a person a pronoun that does not correspond to a person's sex. That it was a law passed by the legislature. The law prohibits transgender employees in K-12 settings from using students' pronouns that do not correspond to his or her sex, biological sex. Citing this law, the Orange County Public Schools sent a memo to all of its staff in August warning that the state could sue the school district if employees do not comply with this law. On the other hand, if new proposed guidance by the Equal Employment Opportunity Commission is finalized as is, school employees could file a federal complaint against the school for workplace discrimination if it continued to ban transgender facility access and, under certain circumstances, preferred pronoun use. So, see the dilemma? Follow state law or risk a state lawsuit. Follow state law and risk a federal lawsuit. Florida schools, as well as those in other states with similar local policies, would potentially have to choose whether they would risk losing their state or federal funding. Sadly, these examples of how the strings attached impact state and local education policies and the state's legal latitude to align its education policies with the state's values, and they only scratch at the surface of this worthy examination into whether the costs outweigh the benefits to accepting or turning down federal education dollars. In 2021, Florida had calculated that the costs to accepting post-pandemic educational funding to the tune of $2.3 billion outweighed any benefits. And they passed on the opportunity to supply the feds with an implementation plan that would have triggered the dispensation of those funds. So, after receiving a very terse letter from the U.S. Department of Education bureaucracy suggesting that Florida school performance would be hampered by the administration's rejection of the federal funds, Governor DeSantis' office responded with the following statement, quote, "At this time, no district has articulated a need for funding that cannot be met with available resources. Whether this may change in the future, the state of Florida will coordinate with the U.S. DOE to ensure students and educators all have the resources that they need," end quote. So this decision came on the heels of watching the federal government sidestep Florida law by sending federal money directly to some Florida schools that were thwarting the state's preemption statutes, preventing those schools from continuing to force masks upon students or close in-person learning. The feds bypassed the administration and promised to send those schools even more money if Governor DeSantis continued to penalize them for harming student learning, because the state had enacted a law saying that masks were going to be optional. At that point, the choice of walking away from the third installment of federal COVID funds for schools wasn't really a difficult one for the administration, even when it meant that at that time Florida stood alone as the only state to reject funds. And our schools and our state have been better for it. So this spring, Florida passed the largest universal educational choice program for K-12 education in the United States. Our student achievement rates have been increasing as our dependence on federal education dollars has decreased. In 2022, our 4th and 8th grade students earned the state's highest ever rankings in each assessment on the NAEP testing and demonstrated historic achievement gap closure for at-risk students at all levels. Our Hispanic students, our African American students, and students with disabilities all scored in the top 10 in every category. So clearly, we aren't suffering for having passed on $2.3 billion in federal education funds. I would argue quite the contrary. And with that, I conclude my testimony. I'll turn it over to my colleague and look forward to your questions.
Thank you very much. All right. We look forward to hearing from you, Steve.
All right. Thank you very much, Chairlady Moody and members of the committee for the opportunity to be here today. As I said, I'm Steve Johnson with the Center for Practical Federalism, and we want to be an encouragement to state lawmakers such as yourself to, jealously guard the authority that you have as a state. We want to help you push back against federal overreach and against federal coercion. Before this, I was a state lawmaker in Michigan for 6 years, so I know the allure of the so-called free dollars that the federal government passes or tries to give to you. And I want to commend your work to actually think about, is it worth the cost? So as I go through my testimony here, kind of two parts. I want to talk about the cost to the federal programs and then some safeguards that you can institute to kind of protect yourself going forward. As we talk about the cost, there's 3 buckets I would put it into: monetary cost, opportunity cost, and independence cost. Monetary cost is just what it sounds like. It's what most of this committee has been talking about. We could talk about the school lunch program, the mountain of regulations there, the things that are in place that basically causes all this food to be wasted, and I could talk for hours on that, but that's a monetary cost. And so just because you get $1 million doesn't mean you actually get that much, because there's a lot of money wasted in administrative costs. And I'm happy to talk about that, but I want to focus on 2 other costs, and that's opportunity and independence. Opportunity costs, economists love to talk about that. It's the idea where if you do something, you're turning down an alternative. And a great example would be with the IDEA funds. If you know anyone in the special education business, you know about IEPs, individual education programs, and it's an idea where when teaching special needs students, we should have an individualized program for them. And that's a great idea. We don't want a one-size-fits-all policy. It's really good. Let's have individualized learning plans. The problem, and this is the problem that we see with so many federal programs, is the amount of paperwork it takes to do these is incredibly burdensome. You talk to teachers that do this, and they'll tell you it's hours and hours of filling out paperwork, and they'll say some of it's valuable, but most of it's not. And so they're spending a lot of time filling out paperwork, focusing on compliance with the federal government, and that's less time that they now have with their students. So that's an opportunity cost where you say, wouldn't it be better if instead of several hours a week doing paperwork, you're actually teaching students? It's what the teachers want, and it's what the students want. Everyone's sort of in agreement with that, but that's the problem when you take federal funds, is you have this mountain of paperwork to do. And these opportunity costs, I think this really highlights the beauty of federalism, is we have 50 laboratories of democracy, right? We have all 50 states competing against one another, trying to solve different problems, and we can look to each other and say, all right, this state did this program, that worked, or they did this and it didn't work. When we start to follow the federal government and they said, here's this money, now you must do things this way, we lose that sense of 50 laboratories of democracy. Now you have less opportunity to see what other states are doing. You have less opportunity for innovation. And so this is really, if you were to turn down these federal funds, it would allow you to innovate in a way that no one else does right now, because you have the money to backfill. It's not a question of, number of dollars. It's a question of, are the rules that are tied to it worth it? Or could you, or even better, could local school districts do it in a better way because they actually know their students more than some bureaucrat in D.C. would? That's opportunity cost. And then the third one, independence costs, and this is, I think it's the most important one. This is what you give up when you take those dollars. What freedoms do you give up? What autonomy, what self-determination as a state do you give up when you take those dollars? And you can't quantify this. There's no dollar amount to your freedom that you give up. And there's a lot of instances out there. Some of them are very big that make the news. There might be, lawsuits about it. But there's so many other ones that are smaller that we don't recognize, but it just sort of begins to slowly chip away at the freedoms that you have. I'll give an example. In the Every Student Succeeds Act, there's one line in there that states high schools must give colleges and military recruiters the contact information of all their students. So any high school or student, their name, phone number, email, mailing address has to be given to colleges and military recruiters. I think that's a bit of a privacy issue. What if parents said, wait, I don't want that information just being handed out? Well, you don't have that choice to say, no, we'd actually rather that, not happen. Say you want to say, maybe some people like that, so we'll have parents opt into that program. Nope, federal government does not allow an opt-in. You have to do that. And so those are the type of things that you lose when you take those federal dollars. It's not just the monetary costs, which is important to note, but it's also those opportunity costs and the independence costs that you lose. Happy to talk more about that. I do want to hit on one thing, and this is sort of the good news. When you take federal dollars, you have to follow certain things, but there are certain things you don't. And as it was mentioned earlier, these guidance documents. This is such an important point that has to be hit. So often what the federal government does is agencies will give guidance documents to state agencies and say, this is what you have to do. That is not law. And a lot of times people assume it is. Well, if the government's giving me a piece of paper saying you must do X, Y, and Z, well, if we want these dollars, then we clearly must do that. That is not the case. And it's one thing, as I kind of go into my second part of my testimony here, some safeguards that you can do to just protect yourself. Even if you're going to take federal dollars, what are things you can do to protect yourself from federal coercion? And these guidelines is a great first step. Most times, you as lawmakers don't even see those letters that come down. When I was a lawmaker, I didn't know that. You'd be told, oh, we have to do this, the feds told us that. I assume that must have been the law. No, usually it's just a letter. Well, a simple solution to that is when a state agency receives a guidance document, they should send that to you. Let's say it's Department of Education, they should send the Education Committee, here's a guidance document we received. And then you can determine, all right, this is very minor, this isn't a big deal. Or you can see and say, wait a minute, no, we're not following this isn't law, and that goes against the wishes of our constituents. So that's one step you could take. Another one deals with legislative authorization of grants. I think a big key we like to see is more legislative involvement in the grant process, and not just agencies taking control of this. And so one thing is, before an agency can go and apply for a grant, the legislative branch has to authorize it. And this isn't unknown. The state of Oregon does this. They have a committee when they're in session that approves it, and another special committee when you're out of session and they want to apply for a grant, that they go and they have to approve it. It's a very simple step. Doesn't mean you're not going to take the money, but it means that as a legislative branch, you're involved in the process, so you know what's going on. The third thing that you can do is a contingency plan for what happens if the federal government decides to withhold those dollars. What happens if the federal government shuts down and they don't pay you? Do you have a plan for when those dollars aren't there? A lot of states have that. Tennessee doesn't really have great contingency plans right now. Most of us have it in our personal lives, right? If I lose my job, I've got 3 to 6 months of an emergency fund. This is what we would do. Well, what would you do if the feds took that money away? By having that plan, it really protects you against that federal coercion. If the feds threaten, hey, we're going to take money from you, you've got a plan, you're ready to deal with that. And then the fourth one, and then I'll be done here. In this whole committee, I've watched the hearings from last week. You guys have done a phenomenal job. This fourth one, I think, has really been emphasized because of that, is when you decide to take federal dollars, there should be a fiscal note with it that explains, here's the cost. Here is the monetary costs that come with it. Just like when you introduce legislation, there's usually a fiscal note. This is what the hit to the budget is. You should know if we receive these dollars, here's going to be the cost. Because there's been a lot of unknowns in this committee where people ask questions, well, what's the administrative cost of this program? And no one knows. Well, that can be fixed. And a lot of times, maybe agencies have that, but they're not sharing that with you because you haven't asked for it. And so that's just a good practice to say, every time we take federal dollars, we're going to know what's the cost of taking those. Happy to go more in depth on any of that stuff. So for now, I'll conclude and answer any questions you might have.
Thank you both very much. A lot to unpack there. I'm looking for any questions from our committee. All right, Chairman Reagan.
Thank you, Madam Chair Lady. Thank you for being here. We appreciate the input. Excuse me. Let me start with the UAPA, as you mentioned earlier, and the fact that that frequently is not getting followed. What avenues do you see the state having to be able to force that issue? By the way, acronyms, I'm sorry. That's the Uniform Administrative Procedures Act. I'm sorry.
Outside of litigation,
Yeah, outside of litigation. Obviously, we can take them to court.
yeah, outside of litigation, I'm not sure that anything would have quite the teeth that litigation would. But I would point to something that we had actually looked up prior to this. And I'll mention that in all of the research that we've conducted, there was not a single case that we could identify where the feds actually pulled funds because of a state not conforming to specific guidelines that had been reached. So I would maybe turn this and say, what better reason do you have for not following?
I can chime in real quick.
Yeah.
It's always going to come down to lawsuits. I mean, at some point, as a state, you can say, you haven't followed this procedure. We're not going to follow your rules. This isn't a legitimate rule. And you can say, we're not going to follow this. But if they decide, hey, well, then we're not going to give you the money, then you're going to have to go to court at some point. It'd be nice to avoid it. And we encourage states to say no to the feds when they're wrong. But at some point, they're probably going to bring you to court. And you will win. I mean, there's all kinds of instances of states winning. But it takes time where you just have to go to the court.
Okay, follow-on question then. We've heard testimony, if you've observed the hearings, about the tangled requirements that exist between the various programs and legal interpretations. How about giving us some of your thoughts on whether or not those tangles are really there, and if they are, how we can untangle them? For example, this morning, our controller of the Treasuries group opined that they really didn't know. So what are your thoughts on that?
I want to make sure I'm understanding the question. Are you talking about if you can like say no to one title dollars and still get dollars from another title? Is that what you're referring to?
That plus within multiple programs within a title or within the Department of Education, for example. I think Title 1 through 4 is within the Department of Education, and the Department of Agriculture has the free and reduced lunch program. Department of Defense has junior ROTC and some food programs. Department of Energy has grants for school construction for energy savings and so forth. So kind of the all-encompassing question is, as you mentioned, can we say no, for example, to one of those departments without affecting the others? Because it was opined to us at the first hearing that the Department of Education thinks that they can cut off all federal fundings if we don't do what they say. So what's your...
They can't cut off all funding because you decide, to reject one section. If you're within, say, a certain title, that's going to become a lot harder, I think. And no one knows because no one's really done this yet. And so this is kind of a good thing to start to pursue and to look into. What you have to remember is the courts have ruled I'll read a quote here from the decision. And I think because we're kind of in murky waters here, but this is what the court is kind of looking at right now. Congress may use its spending power to create incentives for states to act in accordance with federal policy. So, hey, we can say, if you're taking this money, you have to follow some things. But when pressure turns into compulsion, the legislation runs contrary to our system of federalism. So when you start to say, if you don't take these dollars and follow these rules, now we're going to go after a completely separate thing, I think that's now getting in the bucket of compulsion. Whereas if you're within a certain title and you're going to say pick and choose, it becomes a little bit harder to do.
And I would follow up, that case is NFIB versus Sebelius, which is the Affordable Care Act challenge. And the court, and I'm not a lawyer, don't pretend to be one, but the court was very clear in this respect that while the federal government can establish an incentive, they cannot coerce, which is what the feds were trying to do in that act, and it's why they separated out Medicaid expansion in that respect.
Following along in that category there, some of the grant programs come down with the ability to take a portion of the grant to pay for the administrative cost for the state to oversee it. However, there are some where it's questionable if they give us enough to do that, and there are some where there is no money that comes to it. So what are your thoughts on that?
One thing I could articulate is to Stephen's point earlier, it behooves a legislative body to create some fiscal notes accompanying those to be able to discern. And in Florida, we have a couple of cases where they provided administrative costs for a short time period, but then we come to find out at the tail end of this grant, all of a sudden there are 5 or 8 or 10 full-time new staff members within government that the state is on the hook for to continue the program after. And so those are some of the things that I would encourage a legislative body to create some guidance on your own when those grants are being applied to ensure that not only are administrative costs covered by the grant, and even if they are, how long of a time period is that for? And what is the state on the hook for after?
All right, shifting topics slightly. You mentioned some of the guidance, federal guidance. I suppose the most famous of which goes back to 2011 with the quote-unquote "Dear Colleague" letters from the Department of Education directing, not advising, but directing states to comply or lose funds. Now, there was a lawsuit. Tennessee was one of the litigants on that. It was in the Sixth Circuit venue docket, whatever you want to call it, which when President Trump was elected 17 days later, he removed that, so the lawsuit was moot. However, it has come back. No longer "Dear Colleague" letter, the rulemaking, which Judge Atchley in the Eastern District of Tennessee has put an injunction on. However, I understand from previous testimony that even that may come up. So what are your suggestions on how to overcome that issue?
Well, a couple things. First off, and I kind of mentioned this, we don't know all of these guidances that come down. Federal government's not required to publicly publish this. And so one of the big issues is we want to be aware of it. So the first step is anytime a state agency receives a guidance, that's got to be made public, be made available to legislators so you know what's going on. That's the first step. Let's know what they're saying. The second time, if what they're saying is not within the law, what Congress passes, or the rules, which goes through the rule process, if they're going above and beyond that, that is not law. And there was actually a time when they sent those out, and it would say, this is not law, or something similar to that effect on there. Guidance documents are not law. Sometimes they're very helpful when you're trying to figure out what's the proper way to turn in a form. There can be some helpfulness to it. But a lot of times, it's also federal government trying to bully states around and say, well, you have to do this without going through the process of it. We've seen this with OSHA, and I know it's not education, but OSHA did something like this where they just reinterpreted something, sent a letter out, and the court struck it down and said, no, you have to go through the rules process of doing this. So first off, I would say, know what the guidance is, and then when they're running contrary to their own laws or rules, you have to be willing to fight in court on it.
And I know it's a bit of a kind of high-level response to your question, but this is why legislatures and the Congress actually doing what it is that they're tasked with doing is so important, because these rules do not have the force of law. Congress has not enacted these specific things. And part of the reason why organizations like ours exist is to point out the fact that, just on a cursory evaluation, we found 103,642 separate guidance documents across all federal agencies. None of them, to my knowledge, have gone through the legislative process in the United States Congress. Now, some may be a component of that, but I would venture a guess that a large number of these are simply assumed to be law when they are not. And while I am not an attorney and do not openly advocate for litigation, there are absolutely times when it is within the state's purview and within their rights and a duty to pursue.
Madam, if I may continue?
Yes, continue.
We heard previous testimony from several groups that some of these requirements that have been mentioned as a requirement to get funding would exist whether we turned the funding down or not. Are you aware of those kinds of things?
Are you talking what they're saying you have state laws that, or
No,
are you talking
well,
about the federal?
Completely apart from state law, purely within the federal realm, that entanglement, intertwined requirement that says if you don't do this over here, we'll take it away over there kind of thing, and or there's a law that says you got to do this anyway, whether we give you money or not. So I'm only interested in the federal side of that.
Right. So once again, it goes back to a lot of this is unknown, but it's going to come down to, is it coercion? Are they compelling you to do something, or is it just an incentive? And so I think when you get away from, all right, we're turning down these dollars, so we don't want to follow these rules, but we are going to go after, this grant over here. As long as you follow the requirements specifically listed out for those requirements, they should not be, because that's in compulsion. That's not using incentives for that funding stream. That's using compulsion with other funding streams. So I think the courts would rule you can't, the federal government can't do that, but this hasn't been litigated yet.
And I'll just follow up on that. I'd mentioned the number 103,000 roughly guidance documents. There's also 186,000 pages of the Code of Federal Regulations. I think the question you're asking is there overlap between those, or is there potential overlap? Likely. Yeah, there's likely some degree in the Venn diagram of overlap. As to where it is or how much the overlap is, I'm unable to comment or know.
So if I might
Please.
extend that question a bit further, the suggestion was made earlier by our comptrollers group that we don't have a document or methodology established that says where the state begins, federal ends, et cetera, et cetera. Does Florida have such?
Not that I'm aware of, no.
You guys will be the leaders.
Man. Okay. To your point that you brought up earlier about the fiscal note requirement for the federal mandates or incentives to take this, how does your state accomplish that?
I'm sorry, could you repeat that question?
The fiscal note requirement that you mentioned for how much it really costs us, we get this much money, but what does it really cost us? So how does
Florida does not have a comprehensive policy on that. I think Stephen had mentioned Oregon may.
Oregon deals with acceptance of federal grants.
Yeah.
Every state's different. Michigan, I don't think we actually had a good program on that. What you'd want to see is maintenance of effort requirement. You'd want to see what's your administrative costs, and then and this is a big one, a lot of people will have the reimbursable funds because the feds reimburse that, so they clearly keep track of that. The big thing is, what is the unreimbursable funds? So what are the numbers that the feds aren't going to reimburse you for? There isn't as good of paperwork with that because there's no one reimbursing you for that. So maintenance of effort and then unreimbursable funds, that's what I would be looking for.
if I could continue along that line, then that fiscal note use. Now, obviously, when you're passing legislation, you get a fiscal note that says if this legislation is enacted, the state will have to pay out this much or will gain this much if it goes into effect. So the program we're talking about, is that predicated on a department saying we want to accept these funds? How does that work?
In Florida, it's done at the agency level. It does not go through the legislative process. It's definitely a hole we would love to see plugged. We've proposed some possible reforms dating back a few years, but yeah, that is done at the agency level.
All right, if I may, you mentioned the IEP routine here, and I agree with you, it's a good idea to have those things, and we have it in state law. The question becomes, though, when the feds demand that without specifically requiring what's in it, what's the measure of effectiveness that you think a state should have to be able to look at the funds and cost versus benefits kinds of things?
I guess what I would argue is I want states to make that determination for themselves. The idea of federalism, we got 50 laboratories of democracy. So Tennessee tries something, another state tries something, then you can look and see what worked well there, what worked well here, how can we innovate, how can we change. So I'm not saying what's the best way to do an IEP and what's the most, what is the most cost-efficient, effective way to provide a robust education for someone. That's for states to compete against each other and try new things and do that. With the federal regulations right now, there's a lack of that innovation. So I don't have the answers, and that's the beauty of federalism, is it allows for different states to try different things and see what works.
And in Florida, to give you kind of an example on the ground, 15 years ago, our achievement gap was far different than it is now. I'm not certain that what Florida implemented would work in Iowa or would work in Tennessee. So to Stephen's point, this is kind of a question best left to those individuals in the state educational infrastructure as well as the legislature.
Okay, I think I understood what you told me there. I want to shift back to the funding within programs. And earlier testimony, they talked about incrementalism and requesting waivers versus just outright rejection. For example, stepping into the USDA grant for the free breakfast, free lunch program, they had various figures they offered us for waste, up to 31% in one category. And that was the general one presented by the Department of Education. That issue, though, is what would our state have to do, in your opinion, to be able to get permission to step into that program and conduct some optimization so that the money that's being currently wasted the waste could be reduced?
I think there's two things there. You can look at a waiver. I mean, a waiver is an option. But you'd have to start to say, all right, what do we think would work best, and then apply for a waiver that allows you to do that, or say, we're going to take it over with existing funds that we have, and we can run it ourselves, free of any federal influence. It's something, I'm not saying I know what's the best way to run a food program. I do know from everyone I talk to, they say it's insane the amount of food that just gets thrown away, because federal rules require that they have to give out certain amounts of food to everyone, even though they know it might not be eaten, and so it just gets thrown away. Well, there's got to be a better way of doing that. Personally, I think local school districts probably know the better way to do it than some bureaucrat in D.C. determining what's the best food program out there. I think a local school district can figure out how to feed their kids a healthy lunch in a cost-effective manner, and I would trust them to do that. If you were to say, you know what, we're going to reject the federal funds and do this with state dollars instead, you could allow schools. You can say, no, we're just going to block grant it to you, and we're going to let you figure out how to do this the best way. And then schools could compete against each other and say, all right, we've actually lowered our waste to 10%. I mean, there's always going to be some waste, but surely we can beat 31% waste. And that allows for those schools to do that instead of, I mean, if you read the school lunch program, it's tons and tons of pages of really prescriptive stuff. And you say, is this really necessary? Do we really need someone from D.C. telling us that, well, you can have a protein-enriched macaroni as a meat alternative if it's prepared in this manner, if it's this thing. Do we really need that, or can we trust the people at the schools to know what's actually right to feed kids with?
One point administratively I'll make on waivers, and it's a challenge to consider, and that is the timing of the waiver request. And I could speak from experience in another arena, that being Medicaid. A number of states during one administration had applied for Medicaid waivers. It was either 1115 or 1132 or 1532 waivers. Those waiver requests were, for lack of a better term, all but guaranteed in working with the Center for Medicaid Services at the time. The administration changed, and all of the work and all of the thousands of hours and hundreds of thousands of dollars that were poured into creating the waiver applications were basically for naught, because the new administration had come in and had put nixed any and all of the waiver ideas. And so as you consider that, you've got to be very careful about timing as it portends to which administration you're working with.
Yeah, anything to add to that?
Nothing to add.
Madam Chair, I'll share the floor with some others, and you can come back to me.
Representative Slater, you're recognized.
Thank you, Madam Chair. Let's go back to the first part of your testimony, if you would, and you brought up first Kentucky and Illinois. And if I understood correctly, both of those situations were loss of funds due to differences in assessment requirements that the federal government required compared to what the state governments wanted for their assessments. Is that correct? Did I understand that correctly?
It was a threat of losing funds.
Okay.
It was, to my knowledge, not followed through on.
Okay, okay, so that answers the question, because I was going to ask what the conclusion was for that. So, well, let me ask one question, going back to Kentucky and Illinois. Was that through, as far as you know, was that through the waiver process, or are you familiar with the process that they may have taken?
To my knowledge, it was not a specific waiver. It was done through regulatory and legislative change and DOE change at the Kentucky and Illinois DOEs. But I'm 90%, 95% certain on that.
Gotcha, okay, very good. And then moving to Florida's rejection of $2.3 billion, correct? And this was in education funds specifically.
Correct.
Okay, so one of the things that we've been asking as a committee is what would the process even look like? So what did that process look like in Florida?
Well, consider the fact that it was supplemental funding as a result of post-COVID kind of legislation that had come down. So the process in Florida's case was basically nothing. We did not go through the process that was required in order to accept those additional funds. So with that respect, it was very easy for Florida to reject those funds. Now, if Florida were to go down the road that you are considering, it would be a more kind of labor-intensive process of how do we backfill the money that we're getting from the Fed for traditional DOE funds.
Okay, so it sounds like that that Florida didn't apply for those funds would that be an accurate statement that they didn't apply for those particular funds, that $2.3 billion?
Yeah, it would be, we turned down the supplemental funding that was available and did not apply for those monies.
Okay, so then in that same vein, and then for both of you, and perhaps Michigan's experience as well as Florida's, we've heard testimony that there is an opportunity for states to apply for funds at the same time, so to speak, somewhat of a seamless process of applying for title funds in bank that wasn't the word that was used in testimony, but all together. Is that the way that Florida does it? Is that the way that Michigan does it?
I don't know if Michigan does it that way.
Okay.
And I don't believe Florida does.
Okay. Okay. Well, I think the answer to the question, since it really wasn't a rejecting of funds. I was going to ask if rejecting those funds affected other funds. But I think it was more not applying for those funds. Yeah.
Correct. And the back and forth between the federal government and Florida, in my opinion, would be kind of parallel to what you would expect to see in turning down any federal grant pool or federal funding pool.
And that seems to be a natural leap that, okay, the way there's really not a rejection of funds in any of this. It would just simply be not applying for funds. Do you feel that's a fair statement?
Yes.
I would want to make sure, talk to the State Department of Education. My guess is there's an annual renewal, right? You usually have the initial grant application, and then if it's a yearly thing, you're probably having to submit some renewal application. And that's where you could say, you know what, we're not going to submit that this year, but Department of Education will know the ins and outs of that process.
Yeah, and to your point, I think that's what we heard from the Department of Education, that it was an annual renewal. So we've tended to use the word reject, whereas I think perhaps it's do not apply for funds. Yeah, okay. And if you would, if you'd go back a little bit to Oregon's legislative involvement in grants there, and dive a little bit deeper in that, because I don't believe that here in Tennessee that we have a great deal of legislative involvement in federal grants.
Yep.
What does that look like in Oregon?
Yes. So the process basically is federal government says, hey, we've got this grant. They tell states, there's this bucket of money, and here's this process if you want to apply for it. And then most of the time what happens is state agencies will begin the application process. Either they are accepted or they're rejected. They get the money, and then they go to you, the legislature, and say, hey, we got these dollars. Can you appropriate them in the next appropriations bill? Instead of doing it that way, what Oregon allows is before they apply for those dollars, the agency goes to the legislature and says, hey, we'd like to apply for this. Can you let us know if we're good to do that? And then in Oregon, you could do it, make it how you think fits best. With Oregon, they just, committee meets and determines, yep, this is good or no, it's not. And then it's a good way, right from the get-go, to say, are we having to change any policies? Are we having to change anything? Like what do we have to do to get these dollars? Or if it's truly the free money they claim it is, you can say, all right, go for it. Or it's worth the cost we have to do. But it allows the legislature to be involved early on instead of at the end when the money's already been taken and now it's almost too late to stop the process.
This may be a little bit too granular of a question. I'm kind of wondering what the timeline looks like. I mean, things tend to move pretty quickly, especially if it's an annual application. You have to overlay that with the budget process at the state level. Any thoughts there? You're
Yep.
a former legislator.
Yeah.
You've lived through that.
So the way that I would understand it is this, for Oregon, it's not for, it would be for new money. So like say most education dollars you're talking about, it's not every year they're having to get approved to go get Title I dollars. Now you've already got it once. It would be the first time they go after it to get approval. And that's why they have a normal committee during session that they can meet real quickly and say, yep, you're good. And then when they're out of session, they've got a special committee that if they say, hey, we want to go get some money, we're not in session, this committee can meet pretty quickly and they can approve it. Federal government doesn't require anything in 2 days. Usually you got some time to go for it. But it does allow you right from it's only for those new grants, not for stuff you've already been getting and you're just getting the annual renewal.
Did you have anything to follow up on?
No, I'm good there.
Chair Lady, I'd like to yield to see if anyone has any other questions, but I may have some follow-up. Thank you.
Yes. All right. Representative Hill, you're recognized.
Thank you, Madam Chair. A couple of quick questions. I want to go back to Florida. It was your testimony that you had shared that it was determined that the cost outweighed the benefit of the couple of $1 billion, and you'll forgive me. Was there a formula that they implemented? Because again, this committee has had a tremendous back and forth to say, well, what's the cost of compliance?
Sure.
Because it is a cost, but that's a pretty bold statement to say, well,
Sure.
Hey, this outweighs again, billions of dollars. So could you speak to that just a little bit, clarify that a little bit?
Yeah, and if you would allow me, I would welcome the opportunity to ask a few folks who are a little closer in the decision-making and get some really specific information for you, if that would help.
And I hope they do have a formula because it could be very helpful as this committee's trying to make a determination.
Yeah, I can make an inquiry with our Office of Policy and Budget and find that out. And it would be, I would welcome the opportunity to get that to you.
And from a national perspective, looking at all other states, the money that they rejected, the ESSER funding that they rejected, was that the first of the larger rejection of that type?
Yeah, it was the third. It was the third tranche.
And well, it was a third tranche. But as far as a state saying, "Oh, thanks, but no thanks," this isn't a good fit for us.
To our knowledge, it was the first time at least a figure of that magnitude was turned down. I could point to then Governor Rick Scott turning down a few $100 million for high-speed rail. back in 2011, but I think the amount was much smaller.
But as far as education is
Yeah, as far
concerned,
as education it goes, it is, to my knowledge, the only example.
how much of that funding was intended for classroom operations as opposed to other things?
I'd have to find that out.
Okay.
Yeah, it's a very good question. I would have to find it out.
Thank you all for being here.
Oh,
And-
thank
and
you.
thank you for your testimony. Thank you, Madam
If I can, real quick, it's not just the monetary cost, right? We can maybe figure that out, but there's those opportunity costs, the independence costs. My guess is the amount of money they would have received, it wasn't going to actually cost them more money than that to take it in, but it's what did they give up as a state in order? What were those requirements? So I think and those are hard to put in a formula of what did you lose independence-wise and opportunity-wise because you took them.
We appreciate you all being here, but please, please help us to be able to hear our guest as we do this work. We are hearing these things for the very first time ourselves. This is a working group. We have made no decisions. We see your signs. We've allowed the signs. We know you want to express to us. Thank you. But please, the speaking out is getting out of hand, and I'm going to ask you to please respect the order of the House in this room and let our guests continue without being interrupted, please. Thank you. Carry on. All right, Representative Slater, were you wanting?
Yeah, let me just follow up on a couple of items. You did give one example of a situation where there may be many who would not appreciate their child's information being shared with college and military recruiters. That's one example. Do other examples come to mind, or has, for example, the Madison Institute compiled a list of examples of requirements that folks may not appreciate?
Ooh, it's a good question. I don't believe we have a direct compilation of examples. And there are a number. We have an entire policy center dedicated to education policy, and gathered a number of anecdotal examples. Those ones that I highlighted were ones that actually resulted in lawsuits. So I felt more compelled to include those there. But again, to kind of piggyback my answer there, happy to provide some more supplemental information if that would be valuable to the committee on those that question specifically.
Yeah, I think that it would be valuable. And you've mentioned a couple of lawsuits, and I would assume that these are federal lawsuits. Any Supreme Court suits that you know of that might be cited in this space that we've been talking about?
Other than the coercion and compulsion clause in the majority opinion on NFIB v. Sebelius, I'm not aware of any.
The other ones I can think of were district courts.
Yeah.
Okay. And then you had mentioned, kind of to that same point, you had mentioned, I think that it's the James Madison Institute that is collected or gathered 130,000 guidance documents. Is that correct?
Well, we had some friends of ours in the run up to this take a look in doing some inventory, and the figure that we had was 103,642 across federal agencies that we were able to find.
Do you know if they've been categorized to for education, the title grants, that type of thing, or would that be possible? Is there a policy group that maybe would be willing to do that work? Or?
It may be possible, and it may not be very difficult, actually. So if you give me, I may want to take some notes on some things that I've got some homework. Happy to take a look at that and figure out if we can divide up by each of the major agencies at the federal level. My guess is that education is going to be a substantial portion of them.
Just real quick to add to that, though, the federal government is not required to publish all of these guidance letters. So that's the only ones we see. And that's where I think there's value. If a state says anytime guidance is sent to us, that's got to be made available to the lawmakers and published. That way we can see. Doesn't mean they're all bad. In fact, most of them are very benign, but we should be able to see them.
Okay. Thank you, Madam Chair.
Representative Reagan?
Thank you, Madam Chair. Excuse me, a couple follow-up questions here. In earlier testimony, there was a mention of direct grants to districts. And I'm curious, in your experience with other states or your research, were those impacted by refusal of any other funds? And since it goes to the district level, does the district have the authority to refuse it, or does the state have the authority to refuse it?
That was a very salient question at the time. So what had happened in Florida's case was several districts, I think it was 5 districts, had outright flouted Florida's law regarding mask mandates. And the districts had mandated masks for in-person instruction. The state said you can't do that. And so they withheld state funds from those districts. Now, there was a court battle over whether or not the state had the right to do that. But the federal, the U.S. DOE came in and provided money directly to those districts to supplement or to offset what the state was holding up. So if the state, in a hypothetical, if the state held back $1 million, U.S. DOE figured out a way to get $1 million to that district. And we saw that as a direct assault on state sovereignty and federalism.
Unless the state proactively tells the school district they can or cannot take those dollars, the school districts have very large leverage to decide what they want to do. There are examples of smaller school districts turning down certain federal programs because it's not worth it to them. So they've always been able to turn them down unless the state, forced them to. And that's, Florida's law says we're going to take even though the state's not taking it. When they flow directly to the school district and not through the legislature, locals have far more control.
To your point, then, you said flouted, basically.
Yep.
Florida's reaction to that was to withhold money, and when it was backfilled, what did Florida do?
Took them to court.
The districts?
Yeah. It was ultimately resolved prior. It was pandemic era, kind of a lot of back and forth at the time. So it was ultimately resolved prior to a court decision.
Okay, I have some follow-up questions then related to as you mentioned, and I think my colleagues are probably aware, the annual renewal of these grants is usually a mechanical process, for lack of a better description. The department knows that certain things have to be submitted by certain deadlines, and they know exactly what they are. Very little change from one year to the next. But what would be required for us in the legislature? Would we need to have a piece of legislation telling them they've got to bring it before us? How would we change that mechanical operation so that maybe Oregon's methodology or one unique to Tennessee would be put in place?
I mean, there's a couple of things there. First off, none of those dollars get appropriated until you pass your appropriations bill. So even though they go and they apply for them and they get the money, it doesn't get dispersed until you, the legislature, votes to send those monies out. So you always have that final say there. As far as if you wanted to be ahead of that, that would be something you'd have to talk to Department of Education, see what's their timeline, when do they have to apply by, and then you as legislature have to make that determination of passing some piece of legislation telling them that they shouldn't do that if you wanted to prevent them from ahead of time. Right now, state agencies, they can apply for anything. They can just go ahead and go for them regardless if you know you're never going to spend those dollars. They can go and still apply for them and get the money, but then it can never be dispersed. So it would be helpful to know, hey, when are you going to apply for these dollars? When do we have to make that decision? Because that's a huge administrative cost, right? The Department of Education doesn't want to actually go through all this paperwork if they're not going to be spending the dollars. So it'd be good if you worked with them to say, what's your process? When do you start applying? When should the legislature, if we're going to do something, when do we need to make that decision? But that's a decision or a discussion you have to have with the department.
Okay.
And if I may, just one other point, mechanically, you've got to figure out how you're going to offset those with state dollars, and that's an appropriations process. So,
Well, the governor's holding his budget hearings now. Our budget's in March. We hold our hearings in February, January, February timeframe. I was concerned about the lead time for asking, for them putting in
Sure.
their request. Two other questions, if you don't mind. First off, the process for withholding by the feds, withholding the funds, I'm not a lawyer and I don't play one on television, but I did read the process. And it looks to me like it's at least a 6-month process for them to withhold funds. They have to give notice, they have to allow time for a quote-unquote cure, which begs the question of who decides what the cure is. But nonetheless, at that point, 6 months down the road, they can demand repayment, according to what I read. So does that fit into what you have described as coercion?
I don't think that would fit into coercion. I think they can do that. So I say if you're going to go down this road, I would make sure you have money ready to backfill that if they're going to go after those dollars. It makes sense that there's a process of we don't just cut off the funds. We're working through sort of due process. But if we reach a point where we realize, yes, we are going to cut it off because you're not following their requirements, if they're legal requirements, then they can go back and get those dollars. I don't think that's coercion as long as the money they're withholding is within the title that you're deciding not to take dollars from. But a lot of this would be adjudicated. I mean, this is an area where there's a lot of questions. It would likely be litigated.
Bad news. All right, other question, then you mentioned that Florida had in fact refused to take funds for the COVID stuff. I suspect that one-time refusal is not going to generate this, but if in fact funds were refused and or incrementally reduced or wavered or whatever the term we want to use, we have a certain amount of FTEs, man-hour requirements that are spent monitoring this process. What was Florida's experience on any reduction in that requirement?
Florida has, I think, the 49th or 50th, or has the leanest state operation in the United States. When you look at state employees per capita, we're 49th or 50th. We did not have a hiring up with respect to the COVID monies, so I don't believe there were any staffing reductions that had come about as a result of turning down that money.
Well, I wasn't so much interested in staffing reductions as repurposing. Perhaps those administrators were sent to the classroom or something, or you don't know about that?
There wasn't anything that needed to be done to the best of my knowledge in that respect.
Do you have any knowledge of any other?
No.
Thank you, Madam Chair.
Thank you. You're welcome. Any other questions popping up from my members here? All right. Well, seeing none,
You're an easy crowd.
thank you. Well, there's only half of us, so we thank you again for making the trip and sharing your insight and taking our questions. And we wish you safe travel and thank you for appearing before us.
And we wish you the best of luck in the determination and discernment that you've got ahead of you.
Yes, thank you. Thank you. We will.
Thank you.
Thank you for being here.
It is a serious task, and we continue that, look at it that way. And I just wanted to as we're closing out today, realizing we don't currently have the next date for our meetings. We thought we would all get through Thanksgiving. So just wanted to acknowledge that we will not see you, many of y'all, till after Thanksgiving. And I hope that you will have a blessed one, and just remember to be thankful. We have a lot to be thankful for each other, and for the process that we get to operate under. And I'm so happy to see it work, and appreciate everybody that's been a part of this. So with that being said, I will now recess the working group subject to to the call of the chairs. So with that, we'll be posting when we get things set. Thank you.